Let's go ahead and get going. My name is Morgan Chaput. I am the attorney for the Child Advocate Program of Pierce County. I also have with me Bailey Zydek, who is, Bailey, introduce yourself.
Sure. Well, good morning, everyone. I'm Bailey Zydek. I am the program counsel for the Office of Civil Legal Aid's Children's Representation Program. I've also been an attorney representing children in dependencies in Pierce County for about the past 8 years now.
So Bailey and I have worked together on many cases, but we are here to talk to you guys today about kind of the intersection, the roles of child advocates, guardians ad litem, and children's attorneys in dependency cases. So I'm going to go ahead and get my PowerPoint up and running. Bailey and I are going to trade off. We're going to walk you through this little presentation this morning. We are absolutely open to questions. So if you have questions as we're going through our presentation, we got a couple of options. You can either pop them in the chat, and we'll kind of try and keep an eye on the chat. Also, you can go ahead and just ask them if you want. We also, at the end of our presentation, I will tell you we do have some scenarios that we're going to work through together. So there is some audience participation required in today's presentation. Okay, so here's kind of the agenda, what we're going to talk about. We're going to talk about the current state of child advocacy in dependency cases. So that's going to be addressing both advocates, guardians ad litem, and then also children's attorneys. There's been some big changes with the Attorneys for Kids bill, so we're going to talk a little bit about that. Bailey's going to talk a little bit about children's attorneys, who they are, what they do, what kids attorneys want us as advocates to know. And then we're going to talk a little bit about volunteer advocates, who we are, what we do, and what information we can kind of share with children's attorneys to help make that relationship better. And then, like I mentioned, we're going to do some hypothetical scenarios at the end to go through just some kind of ideas, some real life things that have happened, how advocates handle that, how attorneys handle it, and ways that we can work together. All right, so I'm going to start talking about the current state of child advocacy in Washington, first referring to guardians ad litem. And I've mentioned this, I think, in every presentation that I do, but a lot of times you'll hear me refer to guardians ad litem versus volunteer guardians ad litem, court-appointed advocates, court-appointed special advocates. In the statutes, it actually is defined that a volunteer advocate is considered a guardian ad litem for the purposes of the RCWs. So throughout the RCWs, it typically just says guardian ad litem, but know that when we're talking about that or when we're reviewing that in the statute, we do include you as a volunteer advocate. That's built into the statute and the definitions. So currently, the statute says under 1334-101 that the court shall appoint a guardian ad litem unless there is good cause not to. So that has been in the statutes forever. That's the way it continues to be. I will note that the statute does also say that if the child is represented by an attorney, then the requirement of having a guardian ad litem is deemed satisfied. So essentially what this boils down to is a child has to have either a guardian ad litem or a volunteer advocate or an attorney. Either one will satisfy that requirement in the RCWs. So a couple of things, you guys all know and love the guardian ad litem duties that are listed in the statutes, but a guardian ad litem shall have the right to present evidence, examine and cross-examine witnesses, and to be present at all hearings. Guardian ad litem shall also receive copies of all documents and notice of all hearings to participate. Some more duties of guardian ad litem that are listed in the RCWs. GAL is tasked with investigating, collecting relevant information about a child's situation, and then making reports to the court about that factual information as to what's in the best interest of that child. We're supposed to meet with, interview the child, or observe the child, depending on the child's age and development. And report back to the court any views or positions expressed by the child on issues pending before the court. We can make recommendations about what's in the best interest of the child, and ultimately that last bullet point kind of boils down the role of a guardian ad litem in these cases, is to represent and be an advocate for the best interests of the child. We don't just look at the RCWs as to kind of defining what a GAL or an advocate does, but we have some other places that we have to look for directions. So it's the Guardian Ad Litem Rules. This is, we typically do it in Pierce County we've done it as a separate training, but now it's also part of the initial core training. But particularly it's Guardian Ad Litem Rule 2. But that's where it details things about confidentiality and our confidentiality obligations, conflicts of interest and how to address those, performing our duties in a timely manner, making sure that we file things correctly. The Guardian Ad Litem Rules, again, specifically Rule 2 is kind of where it outlines some additional responsibilities of Title 13, well, of any Guardian Ad Litem, but then specifically for us is Title 13 GALs. Your court may also have local superior court rules. So there are local Guardian Ad Litem rules. Those are a little bit more about the kind of mechanics of your specific court, things like when to file motions, how to note up a hearing, things like that. But they do give some direction and some guidance for the Guardians Ad Litem on how to operate in the case. And then we also have case law. So case law is cases that are decided by either the courts of appeal or the state Supreme Court, and they are the ones that are interpreting the laws and the statutes. And so we rely on the information they provide as well to kind of guide how the Guardians Ad Litem do our work. So in addition to advocates, Guardians Ad Litem, who are advocating for the best interests of the child, in Washington State, we have attorneys for children. So Bailey's gonna go more into the new statutes that have passed, which went into effect, I think, in July. So this is kind of, it's not current, but it's recent history here for attorneys for kids. So one of the obligations that we have under the RCWs is that both the Guardian Ad Litem and the social worker have to inform a child, if the child's 12 or older, of his or her right to request an attorney and to ask the child specifically if the child wants an attorney. The GAL is supposed to report that position to the court. So say I spoke with the kid on this date, explained that they had a right to request an attorney. This is what they said about that. And then in addition to telling the court what the child said, we also have to make an independent recommendation as to whether or not appointment of counsel is in the child's best interest. That's both required under the statute. So in looking at whether the court would appoint an attorney for a child, this is the evaluation that the court would do before the new legislation passed. So the court would basically take a look at what are called the Kent factors. And that's a number of factors from a case called Kent, where the court would evaluate whether it was appropriate for a child to be appointed an attorney. So the things the court would consider, and this is primarily, it's coming from the last case that really addressed it was a case called EH. But it would address the interests of the involved parties, so specifically the child, but then also looking at the interests of the parents and the department. If having an attorney on the case for the child would provide some additional decisional accuracy for the court. So if that person would be able to provide some additional information to help the court make an informed decision. You have to look at what resources are available. Are there attorneys available to help represent these children in dependency cases? If there's a situation where the child's express wishes are different than, I just realized my slide is wrong, express wishes versus best interests. So the express wishes is when the child is specifically asking for something. So the example I always use is if the 5-year-old who wants to live at Disneyland, that's their express wish. Whereas in our case, we're advocating for the best interest of the child, and we may say it's not in the child's best interest to live at Disneyland. So looking at, is that a specific situation that we have going on here? The age of the child, obviously, some older children are better at articulating their need for an attorney than younger children. Bailey's going to talk a little bit more about how attorneys deal with nonverbal children, but looking at the age of the child is something that the court was evaluating. And then if the child had a specific position on a proposed decision that was actually before the court. So the example that I would use is if the department was looking to amend a child's placement, would the child benefit from having an attorney to advocate for something specific that they want with regard to a placement decision? So those were the factors that the court was considering in determining whether or not counsel for a child was appropriate in dependency cases. A couple of other places where children were appointed counsel in dependency cases, if a child was legally free for 6 months, once they've been legally free for 6 months, they were generally appointed an attorney. youth entering into an extended foster care situation. So if they were 18 and older, they would be assigned to counsel to help kind of usher them into that program. Both of those two factors have been incorporated into the new statute. So Bailey will talk about, it's kind of a slow rollout, but both of those are accounted for in there. So that's not changing. You're still getting an attorney if you've been legally free for 6 months, or if you're turning 18 and entering into foster care. All right, so that's kind of the current state of advocacy for children in Washington. So I'm gonna stop sharing my screen and turn it over to Bailey, who's gonna talk about some of the upcoming changes.
Great. Let's see if I can do this right. There we are. Okay. So I'm going to just talk a little bit about that new law. It's codified as RCW 1334-212. I might slip up and call it HB 1219. That's kind of how I've been interacting with that piece of legislation. So they're both the same thing, but we call it the right to counsel law. And so I'm going to talk a little bit about what it does and when it's going to go into effect. So essentially, at the end of the day, this law is one that provides counsel for all children in dependencies 8 to 17 years old. The expectation is that a child will be assigned an attorney at or before that 72-hour hearing, that initial shelter care hearing. And for children who are already in dependencies at the time that this legislation is implemented in their county, they will be assigned an attorney at the next kind of possible hearing as soon as possible, right? It also guarantees the right to counsel for children of all ages when a determination petition has been filed. So if a child between 0 to 7 years old does not have an attorney at the time a termination petition has been filed, then one will be assigned to them. For those children who are very young, who may have already had an attorney assigned to them prior to the filing of a termination petition, they will continue to have that attorney. And children, 8 to 17 will continue to have counsel through the termination proceedings. It won't be 2 different attorneys. They just keep the same one. This law also establishes a requirement that attorneys for dependent children render what we call standards-based legal representation. And these standards, as we call them, were first established by the statewide children's representation work group in 2010. It's significant that this new law specifically references those standards and requires that attorneys adhere to those standards when representing children in dependencies, because prior to HB 1219, there was a very limited requirement for attorneys to adhere to this standards-based representation. And that's kind of beyond the scope of this presentation, but I'll just suffice it to say that it really only applied to attorneys providing representation for legally free children. But with this new law that has changed, and hopefully the quality and consistency of quality across the state for children's representation will improve. I've also just noted in the slide here that in addition to kind of delineating the standards of representation for children in dependencies, these standards will also establish training requirements for attorneys and caseload limits. So how it came to be, right? This is my next slide. This is not a piece of legislation that just kind of appeared overnight. There have been efforts to try to expand mandatory representation for children in foster care for many years. In fact, some years ago, the legislature mandated and funded a study that looked at how representation of children in dependencies might affect the outcome of those dependencies. This pilot program, as we call it, was implemented and overseen by the Washington State Office of Civil Legal Aid, also known as OKLA. They collected data from the years 2017 to 2019. And during that time in the pilot program, all children in dependencies had attorneys from birth to aging out at all stages of the proceedings, termination and pre-termination. Our subject counties were Grant and Lewis County, with our control counties being Douglas and Whatcom. This pilot program was significant, and it showed meaningful impacts on case outcomes for children. The most notable of the impacts being higher rates of reunification for children with their parents and or placement with relatives resulting in a guardianship or adoption. We also saw significantly less placement disruptions when children had attorneys at all stages of the dependency proceedings. Oh. There we go. My slide was fighting with me. Implementation. So this, I'm having, there we go. Not sure what's going on. So OKLA is the agency that's tasked with implementing this legislation. That was the same state agency that oversaw that pilot program in Lewis and Grant counties. So they're going to implement it and oversee the operations once implemented. Prior to this new law, as you may be aware, there was a county-based system of managing and overseeing counsel for children, which again resulted in kind of disparate outcomes for kids in dependencies and their experiences in not only the quality of representation, but just in the appointment of counsel. As OKLA goes into these different counties and implements that legislation, we are tasked with kind of prioritizing continuity of counsel. And that means that if you have kids on your caseload that already have attorneys, we are, to the best of our ability, going to try to maintain that attorney for that child to minimize disruptions in the child's life and to promote, those relationships that have already been built. This implementation is going to be phased in over the next 6 years. It's not going to happen overnight. Our first 3 counties will be operational by July 1st, 2022. We do have a tentative phase-in schedule. I'm only authorized to really talk about the first 3 counties. We're expecting that Yakima, Lewis, and Grant will be the first 3 counties wherein OKLA has fully implemented the legislation. And we will have implemented this legislation across the state by January 1st, 2027. The schedule that we've chosen as far as which counties to prioritize is designed to address racial disproportionality and disparate practices across counties. This was expressly mandated in the legislation that OKLA look at those counties where there's either higher rates of racial disproportionality, counties that lacked a system of appointing attorneys prior to this legislation, or counties where we see a higher rate of dependent children compared to the rest of the state. So that is kind of a rough overview of the legislation and what you can be expecting to see happen over the next 6 years. I'd like to transition into a discussion about the role of the child's attorney, what we do, why we do it, and how we as attorneys and advocates might be able to work together for the benefit of these children. First, I'd like to just discuss a little bit what kind of the foundation for being an attorney, what you can expect, the background and experience of any attorney that you're encountering in these cases. So schooling. Every attorney you meet is going to have at least a BA in any field. There's no particular field an attorney has to get an undergraduate degree in. In addition, they also have their 3 years of law school to get their JD. A lot of people think that there's, a specialty or a major or a minor in law school. There's not. It's all the same degree. There are no specializations. All attorneys also have to pass at least 3 examinations. I'm sure everyone's familiar with the bar exam. We also have an ethics exam that we have to pass, and then the Washington state law component, which is the easiest of the 3 because it's the only one that's open book. We also have to complete 45 hours every 3 years of what we call continuing legal education, or CLEs. And then there's an additional public defense CLE requirement. It's not above and beyond the 45 hours that the Bar Association requires, but it's typically specifies that a number of those hours have to be related to child welfare or indigent defense. So the meat of the matter. Why do attorneys do what we do? My hope is to kind of highlight for you or give you just a sense of where we're coming from, because I know a lot of the times from an outside perspective, it can be kind of baffling or it may be even frustrating to see attorneys make the decisions that they're making or do the things that we do. So I hope to kind of give you a sense of what's guiding us and motivating us as we represent kids in these cases. So the big thing is there are rules. that attorneys have to follow. They're called the Rules of Professional Conduct, and all attorneys licensed to practice in the state of Washington are subject to the RPCs. These rules, the RPCs, dictate that attorneys for children render what we call stated interest representation, not best interest. This is an ethical obligation that forms the very foundation of the attorney-client relationship. And in fact, rendering best interest representation for kids would be unethical and could make an attorney vulnerable to losing their license. I'm going to talk a little bit about some of the key RPCs. There's a ton of them. We have to follow all of them. But the ones that I think really impact children's representation the most and might kind of help you as GALs and advocates kind of understand why we're doing what we're doing will be highlighted here. So the first one is RPC 1.2, called Scope of Representation and Allocation of Authority between Attorney and Client. This is the RPC that kind of lays out that stated interest representation. In a nutshell, this RPC says the client gets to decide what the objectives of the representation are. They get to decide what their goals are. They get to decide what they want to see happen in their case. And it's the attorney that gets to decide kind of the strategy for that, how we're going to help our client achieve that goal. Then there's RPC 1.4, communication. This RPC establishes kind of the minimum ethical expectation of communication with a client. We're expected to explain things to our clients in developmentally appropriate ways, in age appropriate ways to the best of our ability, so they can make informed decisions about their case. This is a tough one, I think, for a lot of non-lawyers working with these vulnerable children, because a lot of times there's maybe information that other team members feel like wouldn't be good for the child to know, or they don't want to have disclosed to the child. But as an attorney, we are ethically obligated to convey information to our clients. We're not allowed to withhold information for the benefit of somebody else. There is a little bit of wiggle room for us. There is I hate to call it an exception, but there's a comment to RPC 1.4 that does say that an attorney in their discretion can determine if conveying information to a child would have really bad kind of consequences, given the timing or maybe the place of conveyance. We are allowed to kind of delay transmission of that information. In real terms, this is what it looks like to me. If I have a piece of kind of devastating news that I know is going to really negatively impact my client, I don't get to keep that from them, but maybe I coordinate with their therapist to make sure that we can talk about it in a therapeutically supported way. So that's kind of how that RPC 1.4 often plays out in these cases. And then finally, we have 1.6, which is confidentiality. Everyone knows about confidentiality, right? The attorney-client privilege. The RPCs make no distinction between children and adults. So kids are as entitled to confidentiality as adults are. And this is another area where in my practice, I've seen kind of some frustration, among team members as to why an attorney might not be sharing information that you as the advocate are expected to share and disseminate. Whereas I don't always, I'm not always going to share what my client might be telling me or what I've learned through the course of my representation. Now, there are some pretty significant exceptions to confidentiality. I won't read all the language from the rule here, but I will just kind of highlight that there is an expectation and a mandate that an attorney will and shall disclose confidential information when the attorney is reasonably certain that death or substantial bodily harm will result absent that disclosure. So I have to be pretty darn sure that either my client is going to be seriously harmed or someone else is going to be seriously harmed if I don't say something. Even in those situations, I am bound ethically to reveal as little information as possible in order to protect my client or this other, hypothetical person that might be harmed. So it's not a blanket, go spill your guts. It has to be very limited and minimized in order to protect those client confidences. And I added here too on the slide, because it always just, as a non-lawyer especially, it always surprised me that up until pretty recently, this was not a mandated disclosure. This was a discretionary one. So up until not that long ago, the Bar Association decided that, you know, if there was going to be death or substantial bodily harm, you could choose whether or not you wanted to disclose, but that has since been changed, thank goodness. All right, so big question I usually get at this time is like, well, what about the super young kids? What about those pre-verbal or non-verbal kids? And the good news is we do have some guidance. And first, of course, we go to the RPCs. There's one called 1.4 concerning diminished capacity, which helps guide us a little bit. But the real standard that we look to and the guidance we look to is contained within that Standards of Children's Representation that I referenced earlier, published by the Statewide Children's Representation Work Group. And these standards say that when you're dealing with a child who is pre-verbal, non-verbal, or maybe just with significant diminished capacity, your stated interest representation shifts to what we call legal interest. And legal interest, oh, I pulled the language. If you'd like to read the language from the actual standards, it's there for you. But I will just say legal interest really boils down to looking very carefully at what the statute says, what case law says, and then presenting that to the court. So for example, if I have an infant and there's a motion to amend placement to a relative, obviously my infant can't tell me whether or not they want to go live with Aunt Mary, right? But I can certainly brief the issue of all the law surrounding relative placements for children in dependencies. And then that is what I would be ethically required to present to the court. This new law that just got enacted this past legislative session does require that a statewide work group reconvene to look at the legal interest model of representation for very young children and to update those standards as necessary and to provide kind of the model for representing children that are very young. And with that concludes my discussion about children's attorneys, what we do, and I will kick this back over to Morgan after I turn off my share screen. Did that work? No.
I think, yeah. Is my screen up now? Is that you?
Okay.
I think so. All right, perfect. We're working on it. All right. So what I'm going to talk about now is, and I'm curious to get some input from you guys as well. These are kind of some things that I came up with. But if we have other things that we think it's important for the kids' attorneys to know about us and what we're doing, I'm sure Bailey would be happy to hear this. This is part of what she's working on in rolling out this new program. I think we anticipate that we're going to be getting some new children's attorneys. And so anything that we can, let them know about our system and what we do will be helpful in working together with them as they get up to speed and on board with dependency cases. So the first thing that I thought of is, a lot of us are volunteers. We do have some staff, guardians Ad Litem, who are involved in this process, but especially we have a lot of really, really committed volunteers. But of course, there are some things with volunteers that is not necessarily with staff people. Sometimes we are more available than staff people because we're kind of not on the clock so much. But we also are volunteers. We may not have as much experience in the courtroom. We may have real jobs during the day that we're doing, and so we can't be as responsive to emails as maybe a staff person whose job it is to answer emails. So just a reminder that a lot of us are volunteers. We do also go through extensive and ongoing training to be a child advocate. So of course we have our initial upfront training, which is the 30 hours, pretty intensive work. And then there are the ongoing training requirements that we have. It's typically 12 hours a year. And then different programs, of course, offer different ways to get that training. But we do have, attending this conference is a great way to knock out all of your training all at once. So letting them know that we don't, we're not just, they don't just pull people off the street, but we actually do go through a lot of training to become child advocates and to do what we do. We oftentimes don't have an attorney to assist us with our cases. There are only 3 counties in the state of Washington that actually have an attorney or attorneys that are dedicated to a child advocate program. I shared this with Bailey when we were prepping our presentation, and she wasn't aware of that. So it's the big 3, King, Pearson, Snohomish, have an attorney who can help. But otherwise, the most programs don't currently have an attorney to help with volunteers. I know that's something that Ryan's been working on and trying to get some funding to help do some regional program attorneys. So programs will have some attorney guidance, but that may be something, you know, it's for some counties, it's not as easy as just have your attorney file a motion. It's not that easy for some counties. We also have strict confidentiality obligations when it comes to sharing information that are different than the attorney-client privilege obligations that an attorney has with a client. So this is in the Guardian Ad Litem rules, but of course, you know, our big obligations are, you know, we can't share information about the case with anyone who's a non-party to the case. So if a child's attorney says, you know, hey, can you let Aunt Mary know about the hearing on Monday or whatever, we may not be able to share that information because Aunt Mary's not a party to the case, wherein the attorney could possibly share that information. So again, we do have different obligations in terms of confidentiality than what an attorney may be. And note, I see Ryan in the chat, if you didn't see that, come to tomorrow's lunch session to learn more about our legislative requests regarding program attorneys. Linda asked, who's a party to the case? So typically that's going to be parents, both parents, their attorneys, the department, so DCYF, their social worker, their attorney, the child and the child's attorney, and us. That's typically the parties to the case. You may have some I don't want to say funny cases, but like if the child was in a legal guardianship with someone before, their legal guardian would be a party to the case. But who is not a party to the case? Relatives, foster placement. So if you have more questions about the Guardian Ad Litem rules specifically, talk to your program. They can probably get you some information, some refresher information on those confidentiality obligations. They can maybe even have you pop into when Ryan does it as part of the core training, you can do that session again. And that's right, the tribe, if a tribe is involved in the case as well, they are a party to the case. So you can share information with the tribe as well. There's a couple, I mean, the core, you've got the core ones, and then there are some unique scenarios. If you ever have a question about sharing information, talk to your supervisor, your coordinator, or your program, and they can give you a little bit more direction. If you want more kind of a general kind of overview, you can talk to your program about the Guardian Ad Litem rules. I know our program has like a little cheat sheet about who's a party of the case, who you can share information with, who you can get information from. Generally speaking, we can collect information, but we can't share information except with parties to the case. The other thing that can kind of be tricky is like you can share information about mom with mom's attorney and her mom, but you can't share information about mom with dad and dad's attorney. So there's some kind of different one ways that go. Yep, Ryan just shared in the cheat sheet there, which is the parties of the case. That's from the Guardian Ad Litem Rules training. Generally, is the tribe represented by one individual liaison or a group of people? It depends. That's the lawyer answer. Sometimes there's a tribal social worker. Sometimes there's one person. Sometimes there's an attorney that may be involved for the tribe. So it really depends both on the tribe and then on the particular case. It also kind of depends on whether or not the tribe has actually formally intervened. Then they'll generally have an attorney involved, or they may just be working with a tribal social worker to see. Okay. All right, so next, a couple of other things that I thought of regarding volunteer advocates and guardians ad litem. We have different access to resources than a child's attorney may. I know in Pierce County, we have a couple of programs such as the Children's Fund. We also have Kid Connect, which are some kind of, I don't want to say booster clubs, but it's resources that we can access to get things for, like I know that I just saw in our team's chat the other day, someone was able to get funding for a child to do horse therapy through one of the funds. So that may be something an attorney doesn't have access to, but something that we have access to. Musical instruments for school, kind of fun extracurricular activities that maybe the attorney can't, they could probably help, get that information to us, but then we actually may have access to the funding that can help that. Whoop, that's not what I intended to do. Hang on a second here.
No problem. All right, I think, shall I just pick it up?
You're on mute, Morgan.
Yeah. Hang on one second. Let me get to the slideshow. Current slide. There we go. We see it now? All right. Hit the space bar and things went crazy. All right. So a couple of other things, again, different access to resources. We visit the child or children very frequently. It depends on the program, what the requirement is, but a lot of times we're visiting children once a month, which may be a lot more frequently than the attorney is able to visit the child, especially depending on caseloads. That's another great thing with us that I forgot to mention as it kind of goes under the we're volunteers, but we have usually a pretty small caseload. Typically, we're only involved with a couple of families at the most. And so as opposed to an attorney who may have a caseload, I don't know what the caseloads are currently, but upwards of dozens of children. So we may be able to have a lot more face-to-face interaction with the children just based on caseloads. We don't mind coordinating our visits for the same time that the attorney goes to a visit. I know a lot of times that happens in our county is the advocate's talking to the attorney and says, hey, I'm going to go visit the kid. Do you want to coordinate that and go at the same time? That's totally cool, but also understanding that the attorney will have to have a private conversation with the child when you're on the visit together. So you could all meet together, but then you'll have to step out, maybe talk with the placement while the attorney is speaking with the child. That's for the purposes of that attorney-client relationship. They have to have that private time and that private conversation. And then just reminding the attorney that, we're tasked with arguing for what's in a child's best interest. And in the course of doing so, we have the ability to change our opinion based on new information. So we may get new information that changes what we think is in the child's best interest, and we're not kind of stuck or dug into a position based on what the child is telling us, or we have the ability to change our minds as we collect information and to let the court know that as we go. A couple of other things. We've been on the case since the beginning of the case. This is probably going to change a little bit because once we're having attorneys appointed at the beginning of the case, especially for those older kids. But a lot of times now attorneys are appointed for children, not at the beginning of the case, but somewhere kind of along the way. So a lot of times we've been on the case since the beginning and we're considered the case historian, especially when we have, the department has gone through, 5, 6, 7 social workers. Maybe it's gone through a couple of attorneys as well. But a lot of times we're a really good source of information for the attorneys because we've been with the child and on the case since the beginning. So we're happy to share information with the child's attorney to help get them up to speed so they can do their best advocacy for this child as well. And we're happy, we can definitely work together when what the child wants is what's in the child's best interest and kind of coordinate some things. We'll talk about that in some of the scenarios that we're going to work with at the end here. But definitely when there are situations where, what the child wants is what's in the child's best interest, to kind of pool resources and work together for what's ultimately going to be best for that child. That's a great opportunity that we have to work with children's attorneys because we're together, we're the advocates for that child. And we can work together to make sure that we're doing what's going to be ultimately the best for that child. Okay, I'm going to stop share and cede it back over to Bailey.
Great. Okay, so I'm basically going to go over much of what Morgan has already pointed out. I think she hit on a lot of great areas that advocates and attorneys can work together on. When I was asked to do this presentation and kind of consider ways in which we can work together where our kind of interests and abilities overlap, these are the things that came to my mind. So the first thing that comes to my mind is, man, when I have a GAL or a court-appointed advocate that agrees with my client's stated interest, we are a powerhouse in court. I think it's really hard for judicial officers to ignore that sort of double whammy of this is what the kid wants and this is what the advocate thinks is in the child's best interest. So it's always a really beautiful thing when our positions align. I can also have advocates address family issues that I, as an attorney, might not be able to sort of authoritatively speak on. And I'll give an example as to what I mean by that. That actually kind of came up for me recently in a case where I, represent the older sibling who's, an older teenager, but there are some younger kids in the home. And a question arose about maybe the relative safety of those younger children. I, as an attorney for my client, I can't testify in a case, right? I can't go on the stand and say, well, this is what I've observed in the home, and this is what I believe the relative safety of the younger children are. It's just beyond the scope of my work and what I'm able to do ethically. And it's also not very persuasive for me, because my interests are in arguing my client's position. But man, if I have that advocate or I have that GAL and I know they've been in the home and they've been working with the family and they can really speak authoritatively on the relative safety of the other children in the home, the dynamics in that home, that can be really helpful to me in advocating for my client's position in any given matter. Related to that is the fact that you guys can testify. Again, the rules of professional conduct prohibit an attorney from acting as a formal witness in their client's case. Not true for advocates, of course. So again, you can speak to things in court that I simply cannot, or you can get information in front of the judge as a witness that I am not able to do. Advocates are also able to speak to represented parties and gather information in ways that I can't do as easily. So where I might have to, if I wanted to get information from, let's say, the mother or the father on a case, I can't call them up and ask them. They're a represented party. It would be unethical for me to do. That's a huge no-no in the world of lawyering. I have to go through their attorney and talk with their attorney. Unless I have explicit permission to be speaking to their client. But again, that's kind of unusual. Normally, I'm just bound to be speaking with the legal parties. If I want to get information from a represented party, I have to go through a whole deposition process, which is a whole thing. It can take a lot of time. It's not fun. And you guys might be able to just pick up the phone and ask the question, right? So you can gather information in ways that are just a lot less complicated, and that can be very helpful on a case. Morgan already kind of touched on this, but I really want to stress the value I see in advocates for children on those cases where I'm coming in and the case has been open for a while. Even if it's just a couple months, I like to check in and say, what do you know about the case? What do you know about this child? Hey, when I go out and meet them for the first time, or there's some sensitive issues I should avoid, or they're triggers for them. You guys truly are the case historians and often have that pre-established relationship with children that I see as being so useful in coming onto a case, especially, and developing that relationship with a child in a therapeutically informed way and a developmentally appropriate way. You guys often can really kind of grease that wheel at times. Related to that, of course, is you guys are a wealth of information on those cases where you've been on and I'm coming on new. And as Morgan also touched on too, it's a big thing I've seen over my years in practice that you guys are just connected to funding resources and fun opportunities for kids that attorneys for children just aren't. And I very much attribute that to the fact that you are part of a network that's very much attuned to that and connected in those ways. Attorneys for children are often, private attorneys, private contractors, or even if they're in a public defender's office representing kids, that office isn't oriented to be seeking out those connections and networking in that way, right? So it's been very nice working together as a team to, get that money for that yearbook, or, for soccer, practice, or whatever the case may be, to really help enrich the lives of kids in the system. And I think that's, so do you want me to just jump right into the hypo, Morgan? Great. Okay.
Maybe we can see if there's any questions about kind of the content before we get working into the hypo.
Great idea. Any questions from folks? I don't know if I can see the chat. Okay. Well, there might be some questions that come up as we sort of tackle this hypo. So what I'd like to do is I'm going to just read the hypothetical I've presented here, prepared for this training, and then we're going to talk a little bit about how I as an attorney would approach this and how advocates might be approaching this situation. So you represent a 16-year-old girl living in a suitable other placement. You fought hard to get her out of licensed care and into this placement. Lately, she has complained to you about how the father of the home has been drinking and that it makes her uncomfortable. When you ask for more details, all she can say is, I don't know, he just gives me the creeps. Your client insists that she does not feel unsafe in the home, just uncomfortable when he drinks. She is adamant that she wants to remain in this home until she is 18. So, when I am faced with a situation like this, here's how an attorney would likely approach the situation. First, we're going to try to get as much information from our client as we can. I'm trying to determine, is she reasonably certain to suffer substantial bodily harm if I keep this information to myself? How vulnerable is she with respect to this person's creepy behavior? I'm going to ask my client what action, if any, she would like me to take on behalf of her to address these concerns. Again, I don't get to impose what I think is best for her. As a, taking off the lawyer hat, my little, red flags would be going up, because we all know creepy can often be a coded term for something much more sinister. But as the attorney, I have to really divorce myself from that kind of impulse and really try to be objective and determine truly what is the vulnerability here, what is, the certainty of harm here if I don't disclose this to somebody else. And then I have to get input from my client. That circles back to the RPC 1.2 allocation of authority. What would she like me to do? What is the goal? Is she just venting to me? Does she just kind of need someone to complain to? Or would she like me to start looking for other homes for her or talk to other system actors? Now, it is an attorney's ethical obligation to counsel their client. So I absolutely could say to this girl, this really bothers me. I'm very concerned that you're describing this behavior as creepy, and here's all the reasons why. Here's some things that we can do. Here's some possible solutions. But at the end of the day, if she tells me, I don't want you to tell this to anybody, we'll just leave it as it is for now, I'm bound to keep that confidential, and there's not really any action I can take on her behalf. And as I've highlighted here in the slide, part of my obligation when I'm giving her perhaps different ideas of how we might address this, I also have to tell her what the consequences of those actions are. So it would be unethical for me to say, hey, do you mind if I tell your advocate about this? Or do you mind if I tell your social worker, without explaining what the consequences of disclosing that would be? And as I've stated, if at the end of the day she wants me to keep this information confidential, given this fact pattern, I am bound by the rules of professional conduct to keep this to myself. Now, how would an advocate approach this situation? And I don't know if folks want to just say things or pop things into the chat. I have some ideas of my own that I kind of guessed how an advocate might approach the situation. If folks want to chime in, I'd love to see that first.
Yeah, I'd be interested to see what people's reactions would be as an advocate if you were to get this information from the child on your caseload.
Great. Yeah, I'm saying ask her for specific creepy behavior, ask lots of questions and gather information. Did you see that the child suggested placement? So Kathy asked, so if my client did say that she wanted a different placement, then yes, I would take the steps as her attorney to vet that for her, to help her achieve that. Mary said, gather information and report to social worker. Another person said we'd ask for examples of creepy behavior and iterate that being specific is fairly important. Pat has a great one. How can I help? That's great. So assuming you've gotten all the information you can, what's kind of the next step for a court-appointed advocate? Is this something you guys are keeping to yourselves? Are you checking in with other folks?
Yeah, one thing I would think I would think that you would want to remind the child of is unlike with Bailey, where she's got that confidential relationship with the child, we don't have a confidential relationship with the child. So you would also, in the course of your conversation, you would need to let the child know that, that you may have to share the information that she tells you, because it could affect her safety and her welfare. And so it's something that you might need to share. It's not a secret that you can keep. Of course, that may shut down the conversation. She may say, oh, forget it. It's nothing. Never mind. I don't want to talk about it. But that is something that you have to remind them of.
That's great. No, and I saw a great one here too. Somebody mentioned that advocates are mandated reporters, and that is such a great point, because an attorney is the opposite of a mandated reporter, right? With those confidentiality rules. But you guys might, under this fact pattern, depending on what you're hearing, you might have to disclose or make a CPS intake.
I think Betty's got a good point there. See if you can visit at different times, especially drop-ins around the time of the issue. Another idea would be maybe if you get the sense that she's not comfortable talking about it in the home, perhaps while this guy is there, try and see her at school. See if maybe she's more open to talking about it when she's at school and out of that situation.
Yep. And someone mentioned maybe talking to the social worker. And that's another great illustration of where kind of our roles diverge, where you probably would be going to the social worker or perhaps your supervisor to discuss what this child told you, whereas the attorney would not. So this is great, and this is kind of essentially some of the points that I made in preparing this slide. I also kind of note that an area where our roles kind of diverge is that you as advocates might start proposing supportive services or establishing conditions to continued placement there if you were uncomfortable with this child remaining in the home, but still felt like you could safely support a placement given certain services or conditions. I like this talk to school counselor. Great. Yeah, so as we can see, there's...
I just want to step in real quick about the school counselor. A reminder, the school counselor is not a party to the case. So we could talk to the school counselor and collect information, but we can't necessarily share with the school counselor that she's reporting these concerns. So maybe talking to the school counselor, has there been like a dip in her grades since she's moved to this placement? Have there been, disciplinary concerns, to kind of collect some other information that may kind of identify how this is impacting her.
Great catch. Okay. Anything else that we might have missed here, folks, of how you might handle the situation?
I have a question. So let's say I call CPS and report it. So I would let the social worker know, but would I also contact you and let you know so you're in the loop?
I would say absolutely yes. So that is the ideal. And again, that's kind of that difference, right? Where there's an expectation that the advocate or the GAL is sharing case information with the parties to the case, right? And I, as the child's attorney, would absolutely be a party to that.
Okay, thank you.
For the child to actually share something like that with me, that would mean at her age that I've been with her at least a couple years. So I would have some background information. I would know whether or not dad has an issue or whether drinking has been an issue in the past. And I think that would more inform what I do. But I agree with the other people. I would need her to explain to me what creepy is. And then I would have to go from there. I might get counseling from my supervisor, or if I'm working closely with the social worker, I might call her that night. But before I jump, since she did say she wants to stay there, I would be very careful, because once you lose her trust, it's gone.
Yeah.
No, this could ultimately end up being a situation where, she wants to stay there, and maybe we ultimately decide it's not in her best interest to stay there. Maybe it's affecting her mental health or her well-being. And so this may be a point where those two things diverge. And so we would have, the child's attorney representing her desire to stay in this placement, and maybe us advocating that's in her best interest to leave this placement.
Great. Was there anything else from folks that they wanted to share or add about how they might approach this? Or shall we move on to the next hypo? All right. Well, I will stop share. You're on mute, Morgan.
I thought, you know, how many times have I heard that in the last 18 months? Okay, so hypothetical scenario number 2, Casey's an 11-year-old boy. He's legally free and represented by an attorney. He also has a volunteer court-appointed advocate. So he's been with the same paternal aunt for the past 3 years. There's no safety concerns. There's never been any concerns with Casey being in the home. And Casey wants to be there. He likes living with his aunt. So unfortunately, the aunt has failed her home study due to concerns around her health and her ability to manage Casey's therapy appointments. So the department, because the aunt has failed a home study, department is going to be filing a motion to place Casey into foster care. There's no other identified relatives or fictive kin. So he's with his aunt, but the department says failed home study, we can't support placement there anymore. We need to move to foster care. What are your immediate thoughts about this scenario? Has anybody seen this happen before? Bailey and I are nodding. We've seen it many times. The department generally has a policy that they can't support a placement of a child in a home with a failed home study. So this unfortunately happens quite a bit. Even if the department doesn't really want to move the kid, a lot of times they have to follow through. All right, so let's go through, we're getting some notes in here. So what are some things that a volunteer court-appointed advocate could, let's take that first one first. We're getting some good ideas in the chat here, but what are some things that volunteer court-appointed advocate could do? So we've got find support for the aunt, maybe find transportation to help with therapy visits, supports in place so the aunt maybe isn't responsible for doing the appointments, supporting for the aunt, support for the aunt, other options, transportation health issues, can't support the move, mitigate deficiencies. Yep, research the home study, careful observation of aunt, extended family supports. Yeah, maybe there's family around who can't be a placement, but they can otherwise offer support. What about for the child's attorney? Are there different things that you think a child's attorney could do? And then we'll let Bailey kind of weigh in whether or not that's possible. Request a repeat home study with extended support. Find ways for the child and aunt to have visitation while the issues are being worked out. I think definitely if the child ends up, if the court does order the child to be moved, then talking about visitation between the child and the aunt is something that would probably be critical. Child's lawyer oppose the transfer to foster care. Possible other family placements while continued relationship with the aunt. Bailey, do you have any other ideas of some things?
Yeah, no, so likely, you know, assuming that my client says, I want to stay with aunt, then absolutely, I would formally be opposing that motion. I'd be filing legal briefing to support my client's position. I might get, you know, if I have funds to get an expert on board, to get a private home study to counter the department's home study. I know I saw someone in the chat kind of mention, well, maybe we could ask for another home study. And DLR, my understanding is that once they've denied it, DLR being the branch of DCYF that does those home studies, once they've denied it, they typically don't go back and reassess. So I might have funds in order to bring on an expert to counter some of the assertions that or the accusations that are established in that DLR home study.
Yeah, so here's kind of the list that I put together, which I think everyone's kind of jumped on these, but yeah, so obviously if they're going to be moving Casey, there should be an FTDM. So advocacy at an FTDM, ultimately the department's going to do what the department's going to do, but making it clear at that meeting, the position of the child and that he wants to stay with his aunt. I know somebody, I think it might have been Katie Brown, mentioned a preemptive kind of motion to preserve placement. We've done that occasionally, but typically we wait for the department to file their motion and then we do a response. It's been very limited circumstances where we kind of jump in ahead of the game and say, no, you can't, like, no, don't move this kid. We've, depending on one other thing that we've done is, the department can move children between foster placements without having to come back to court. If they were doing like a foster to relative or relative to foster, they do have to come to court. We've had some times where we've had issues with a foster placement that's had CPS intakes or licensing intakes or something. And so the department wants to move the child from a foster placement to another foster placement. And they can do that without going to court. And so that's cases where we have stepped in and we've said, hey, if the department wants to move this child from this foster placement, we want them to have to come to court to do it so all of the parties can bring briefing and argument and that kind of thing. So we've done that before. That wouldn't exactly apply in this case because it's a relative to foster situation, but that's something that we have done. In-home services, is there something we could put in to help out, especially with that therapy issue and transportation or, helping scheduling or whatever that looks like. I did see a great note from David Lewis in the chat. So getting some more specific information about why DCOAF believes the aunt's health is preventing her from parenting the child, and getting some information from the aunt's doctor, if she's willing to get that information. If it's something that she's, receiving ongoing care for and the doctor says it's, it's not actually a concern, that kind of thing. And then, assist with securing a private home study. I know once DLR generally denies a home study, that's it, that's done. I think you can try and appeal, but I don't think it ends up going anywhere. So that may be something else, but talk to the child's therapist in school to see how he's doing. I know this is something I've seen children's attorneys do all the time, where if this comes up, is they do talk to, the therapist, the school, they get hopefully, letters or documentation to help kind of supplement their briefing to show how detrimental it would be to move this child from the placement. Sometimes that helps the court make a decision about keeping the child where they want to be. Any other ideas for what the attorney could do? I think the next slide is about what a kid's advocate could do. But
I will just throw out there as well that especially if we're not able to get a private home study so that an adoption can go forward, I, as the child's attorney, might file for a guardianship, a Title 13 guardianship for the child, because contrary to what the department often says, the law does not say that we needed a home study at all, much less an approved study to establish a guardianship for a child in a dependency. And so I, as the child's attorney, can act as a petitioner in that matter. And I've done that many times in cases where my kid wants to get out of the system. They're like, adoption, guardianship, doesn't matter, like, get me out of here. And so an attorney might also take that course of action after consulting with the child.
And so, like, for example, I've got one that I think we just emailed to Bailey a couple of weeks ago, but it's a child who's in a placement that's not, DCOAF doesn't approve of the placement. And so Bailey's moving forward with an adoption without the department agreeing to it. And we filed, wrote up a declaration on behalf of the guardian ad litem to support the child remaining in the placement and achieving permanency with this placement. So we believe that's in the child's best interest.
And it worked, by the way. I don't know if that adoption did go through. So.
Oh, great. Good news. All right. So then this is just a brief list. We've already talked about a lot of this kind of stuff, but things a volunteer court-appointed advocate could do. Again, advocating at an FTDM for Casey to stay with the aunt. We know the department's probably locked in their position, but making it clear that we're not in support of any change in placement and that we'd be addressing the court as such. Again, a motion to preserve placement, maybe not in this case, but in some other certain circumstances. Opposing the state's motion to amend placement. And like I mentioned with the attorney, we've sometimes also, gotten information from the child's therapist, from teachers, I had one we did the other day where the child's in swim lessons, and we got documentation from the child's swim teacher about how great the child was doing in the placement. So just kind of, collecting information to help support our position that we could file with the court. We want to give the court as much information as it can to make an informed decision that we believe is in the child's best interest. I'm recommending in-home services to remedy concerns, things like thinking kind of outside the box, things like transportation. If transportation is an issue for medical appointments, okay, what could we do to address that? Depending on if the child receives any other sort of state assistance, if there's like DDA or something like that, could that help step in and support in some different ways? And probably talking with the aunt and finding out what she wants help with, and seeing what kind of things we could do to, it's kind of, if the department's asking for the child to be moved and we're saying, no, absolutely not, the child cannot be moved. But it's always better to, rather than just say, no, we don't want the kid to move, we say, no, we don't want the kid to move, but also here's some ideas of things that we can put into place to remedy some of the concerns that the department has and to make everyone, a lot more comfortable with the child remaining in this particular placement. Any other ideas of things that we could do as advocates to help ensure that Casey stays where he's at? The other thing too, like in this scenario that we would highlight is, he's been there for 3 years and there haven't been any sort of reports of safety concerns. The department's presumably been going out there to do health and safety visits every month and they haven't had any other issues. They haven't had any other reason to remove him from the placement. It's just this failed home study and that's what they have to do. So again, does this sound familiar? Has this happened to you guys before? Some of your cases? Yeah, Linda's got a good idea that could lead to another little bit of a conversation, but let Casey talk to the court and answer any questions that the judge has. Bailey, maybe you want to talk a little bit about that, about having your client come and talk to the court.
Yeah, absolutely. I think that's a great, I'd use the word strategy, but oftentimes with these cases, so much of what a judge is saying is written pleadings and a bunch of lawyers and advocates making arguments, and to have a child come to court and be seen by the court really humanizes that child, right? And really brings a face to the case. And it also, I think, empowers children, that do feel comfortable speaking up. Sometimes even just being able to be there and bear witness is important for a child and can reduce anxiety and uncertainty around the legal proceedings. So I know for me, as a matter of practice and truly as an expectation under the standards of representation for children in dependencies, we as attorneys are expected to let our client know absolutely that there's been a motion filed and that there's going to be a hearing, but that the child has a right to attend and to address the court if they would like to. So I think that's a great idea, assuming, of course, that the child is feeling, comfortable and is adequately prepared, because of course, court can also be kind of a scary, stressful place.
And also you could, if the child didn't want to come, they could also write a letter to the judge that you could provide to the court. I know that we've done that several times as well.
Absolutely.
So I see Ryan, it looks like he's working on trying to get some legislation passed that specifies that if a child's been in a placement for a while, that suffices as a de facto home study. So I'm sure Ryan would be more than happy to talk to you about that if that's something that he would be interested in working on. I see Mary says she's had a case that had a home study done with contact entirely on the phone and no in-home visits. Agreed with the failure on the home study, but thought the thoroughness of the home study was not perfect. Yeah, and I'm guessing that this was probably done in COVID times. So I've seen a few of these where there's, it's not as robust as we would like it to be. There's some things that are missing without having seen the home in person. And that could be something wherein, in that case, if you didn't agree with the failure of the home study, that could be something that you could point out to the court, is that, this home study was done only virtually. There's just saying, maybe there are some additional things that the department could do with its home study that may change its viewpoint on failing it. I don't know how good of an argument that would be, how much the court would take that, or how much DCYF would actually, or DCYF or DLR would actually change the home study based on that, but could be something to point out to the court. So I think we have some time now at the end for just answering any other questions that you might have. Otherwise, we might be done a little bit early today. But that's both my email and then Bailey's email up there as well. We're happy to answer questions to the extent that we can without providing legal advice to you. But if you guys have any other questions right now, you can pop them into chat or go ahead and just speak on up and we'll address them as we can. I see Linda's got a mention there that says, I had kids in a foster home that looked good on Zoom, but had all kinds of issues of safety that only surfaced when the kids went to respite care. Yeah, that's, you know, you can hide things on Zoom, right? I mean, you guys.
Uh-oh. Morgan appears frozen from my end.
I've got going on. You don't know, my dog is laying in a bed right here. Snoozing. Get him up. Oh, sorry. Is that better?
Yeah, there we are. Yeah, you're back.
Okay. Yeah, I got my internet connection is unstable message. So yeah, unfortunately things hide on Zoom. And I know that there was, at least in our county, we had some concern that when kids were going to start going back to school, were we going to see an increase in intakes because kids were seeing more adult mandatory reporters. So that was a concern that we had. Sarah has a question. How long do lawyers stay with children once they age out? Bailey, you want to take that?
Yeah, that's a great question. So in classic lawyer fashion, it depends. So, and really what it depends on is whether or not the child is elected to participate in extended foster care services. So if they've decided they want to participate in extended foster care, they have a legal right to have an attorney throughout the duration of their time in extended foster care. Or if they, if they leave and come back, which they're allowed to do as many times as they want up until the age of 21. But after 21, once they are truly, aged out of the system, no longer eligible for extended foster care services, I'm off the case, just like anyone else involved in that child's life. I have I can, of course, choose to continue to maintain communication with that client, of course, after my representation has concluded. But at that point, I would no longer be acting as an attorney in any, way, shape, or form after that. You're welcome.
And that's something that's different. A difference between child advocates and attorneys is generally once the child reaches 18, we are off the case, but the attorney can remain on after that. There are some special circumstances I know in our county where we do remain on, particularly for medically fragile children or significantly developmentally delayed children. But generally speaking, that's one example of a difference between attorney and an advocate or GAL is we should be automatically off once a child reaches 18. And again, we too can, depending on your program, you may be able to maintain a relationship with the child, but that's going to be specific to what your program dictates. Any other questions, chat or out loud?
There are no bad questions. So if you're sitting over there feeling like, should I ask? You should just ask. Now's the time.
I'll ask a dumb question. I mean, that's a question.
Great.
Thanks for all your insight and your expertise. But a kiddo that I worked with, a teenager, she really was not happy with her attorney. As soon as I met her, she complained and said that she felt like he really, or they, I shouldn't say he, that the attorney really didn't listen to her. Really, she didn't feel like the attorney was really listening or cared about it, frankly. And is there an opportunity for a kiddo that's close, a teenager or even younger to request a new attorney?
Sure. Yeah. So absolutely. So if an attorney is not meeting those ethical obligations that they have to a client, then this child definitely has recourse in a number of different ways. Probably the most practical, where that's going to get the child the most results, is either filing a formal complaint with the organization overseeing the representation. So right now, before this law is fully implemented across the state, that might mean going to the county. I know if they are contracted with OKLA to be providing that representation, the Office of Civil Legal Aid, that will be, by 2027, will be handling all contracts and all, oversight of children's representation. We have a website, got a form right on there. We have a form that the youth can fill out, or their caregiver can fill out, or someone else involved in the system. If you as the advocate have observed something that an attorney is, they're not showing up to FTDMs, they're not showing up to staffings, they're not showing up to court hearings. Your kiddo keeps saying, like, my attorney never calls, or my attorney, whatever the case may be. There definitely is a system for kind of reporting that. The child has a right to ask the court to appoint a new attorney. And in fact, if that child, and again, as an attorney, I would need to be hearing it from my client, right? So you as the advocate can say, hey, Susie wants you to get off of her case. Like, you might be able to get on the phone with Susie, right? To kind of say, like, hey, I want you to ask the court for you to withdraw and appoint a new attorney. An attorney has an ethical obligation to follow that request. Whether or not a judge grants it is a whole nother issue. But there is definitely recourse there. I will also say, though, too, sometimes just having a frank conversation with the attorney, like, hey, this is what's been reported to me. It might be, that attorney might think, hey, this is a pretty quiet case, not a whole lot going on. She's got, there just might kind of be a misunderstanding or a disconnect. And so maybe that gives them the awareness, like, oh man, this is a child I need to be checking in with more, or I might not have understood them. So that would kind of be my hope would be, of course, is that it could be resolved just by saying, hey, this kid's got some concerns, and then the attorney changes their course of action. But if there's not an improvement in that representation, that child absolutely has a right to have some sort of recourse, right? Whether that's filing a bar complaint, which is probably going to be the slowest and least effective, to asking the court for a new attorney, or just filing a complaint with the overseeing agency.
And I would talk to your program. Yeah, talk to your program first, because they'll know who they need who to get in contact with. So we've handled this in our county a couple of times, and so we've kind of, when that comes up, is we figure out who, we know who to talk to, and what steps to take. So that would be my suggestion, because they'll know the correct email addresses to get the information to.
Correct. And I just have to stress, we at OKLA especially take that very, very seriously. We expect our attorneys to be rendering the standards-based representation for all kids, no matter what's going on. So thank you for that question.
All right, well, thank you guys so much. We appreciated having you all here listening to us chat with you this morning. Please fill out your evals, and feel free to contact us if you have any questions.
Great. Thank you so much. It's been a real pleasure and an honor. Thank you for inviting me to speak this morning. This was wonderful.